When you look at the mechanics of power in Washington, there is a specific kind of theater that happens in the Senate Judiciary Committee. It's quiet, it's polite, and yet it is where the next 40 years of American law are forged. I was recently going through a transcript from a 2026 confirmation hearing that felt like a masterclass in this polite warfare. It's an exchange that reveals the deep anxieties both parties have about the future of the federal bench, especially in an era of massive executive overreach and rapid litigation. The conversation starts almost too cordially. Senator Chris Coons and Senator Peter Welch are deferring to one another with a level of after you sir politeness that you only see when the room is about to get very cold. Coons opens with a technical question that sounds dry. Diversity jurisdiction, but it's actually a vital gatekeeping issue. He's basically asking if the $75,000 threshold for getting a case into federal court is too low for 2026. If it's too low, the federal courts get swamped. If it's too high, people lose access to a certain level of justice. The nominees predictably play it safe. You can hear it in their voices. That practiced, neutral tone that says, I understand the concern, but I'm not going to give you a soundbite. But as we pivot to the more contentious questioning of Miss Westerkamp and Miss Lane, I have to ask, if you want to stay on top of these judicial battles and the daily news that shapes our legal landscape, hit that subscribe button right now. We are in 2026, and the courts are becoming the ultimate referee in our political system. If you haven't done so yet, please hit subscribe and join our community of over 1 million engaged citizens who want to understand the real power moves in D.C.
Mr. Chairman, I believe, am I the last
Yes.
senator to question?
No, Senator Welch.
Would you like me to defer to you, Senator? I am happy to. Yes, I'm also willing to defer to you.
That's a request.
It is not, but it is a genuine offer.
I will seek to you.
Thank you, sir. Congratulations to each of you and to your families. I appreciate your willingness to step forward and serve. I have just a general question that I've been working on with one of my colleagues. The amount in controversy that creates diversity jurisdiction has been set since 1996. The amount that is at issue in most cases and the volume of cases has gone up dramatically. Could each of you just briefly tell me something about why you think we should or should not increase the amount in controversy required to create diversity jurisdiction, and why that would be an appropriate thing for this Congress to do or not? Briefly, Ms. Clark.
Senator Coons, as you pointed out, the amount in controversy in diversity jurisdiction is $75,000. And at this stage, that's a very low bar, especially when it comes to civil litigation, to allow a potential plaintiff or even a defendant to remove a case from state court into federal court. I have not thought thoroughly about what that number should be, but I do recognize that that is a low number.
Thank you, ma'am. Ms. Clark, Ms. Lane, forgive me.
Senator, I think that would go to kind of an ongoing debate about what's appropriate. And as a nominee, I wouldn't want to get too far out over my skis on that one. But I would just say that, as a federal judge sitting in diversity jurisdiction, I would follow the $75,000 threshold until Congress changes it.
Sir.
Thank you, Senator. My practice has been almost exclusively in criminal law, but I'm certainly aware of this low threshold that exists. I think, again, in terms of Congress increasing that threshold, I'm hesitant to kind of comment on potential legislation that this body might take up and support it or be against it. But I definitely understand the concern. This is not so much of an issue that we've seen in the District of the Virgin Islands, but I do understand it's a nationwide problem.
And does the elevation of cases from territorial court to federal district court have the same dynamics and impact on volume as it might in the other districts being represented?
I think I don't have metrics for the other districts. I think this is less of a problem in the District of the Virgin Islands, but it's an issue that's there, and it is something that's been debated in the bar. And again, I just think it would be I'd just be hesitant to comment on potential legislation as a nominee.
Ma'am. Ms. Westerkamp.
Senator, the Court of International Trade is a court of limited jurisdiction, and so it doesn't really apply.
So maybe I'll move on to questioning you about something directly in your bailiwick. Ms. Westerkamp, just if you'd briefly tell me what's your role been in advising President Trump on the tariffs that he issued under IEPA, the International Emergency Economic Powers Act?
Senator, so consistent with past precedent for nominees who have appeared before this committee, who worked in the executive branch and cognizant of the various privileges that the executive branch enjoys, I can talk about specific matters, but not the advice given or to whom the advice was given.
Now, let's talk about Miss Westerkamp. This is where the transcript gets spicy. Coons pivots to her role in advising the president on tariffs issued under IEEPA, the International Emergency Economic Powers Act. We are talking about a $160 billion problem. The Supreme Court recently ruled 6-3 against the administration, declaring those tariffs illegal. Coons is trying to get her to admit what she told the president behind closed doors. Her response is a textbook executive privilege dodge. She uses phrases like cognizant of various privileges and consistent with past precedent. As an analyst, what I see there is a nominee who knows the law but also knows how to protect the client. In this case, the president. The real tension comes when Coons pins her down on her recusal promise. In her questionnaire, she said she would recuse herself from any case touching her work in the White House counsel's office. On the stand, she starts adding caveats, as Coons calls them, saying she would consider it. That shift from "I will" to "I will consider" is the kind of subtle verbal gymnastics that makes senators very, very nervous about a lifetime appointment.
Did you discuss with President Trump how CIT should or might rule on the legality of these tariffs?
Senator, that gets, again, into areas that I can't discuss, but I can tell you that I did work on various executive orders citing IEPA, and since the Learning Resources decision, I have not had further work related to that, and I'm also not working on any of the ongoing litigation that's currently back before the CIT.
Given that the Supreme Court ruled 6-3 against the administration's position and declared these tariffs illegal, have you discussed with the president your views on what should be done to refund $160 billion now that the Supreme Court has invalidated those tariffs?
Senator, again, that is a matter of active litigation before the CIT, and it's a matter of public debate, too, with different economists as to how to tackle that question. And so as a judicial nominee.
For you, you wrote in your Senate Judiciary questionnaire you would recuse in any case touching upon work you performed while in the counsel's office. Would that cover everything that relates to IEPA or tariffs?
Senator, pursuant to 28 U.S.C. 455, which is the statute governing recusal, I would take any recusal matter very seriously, discuss the matter with my colleagues, and determine whether recusal is appropriate. And I think with the various subject matter that I have worked on at White House counsel's office, I would very seriously consider whether recusal would be appropriate.
Your answer in the questionnaire was not as carefully cabined or constructed. It was you would recuse in any case touching upon work you performed in the counsel's office. Was that not accurate?
No, Senator, that is accurate.
Last, if I might, to Ms. Lane, I'm deeply concerned by the lack of legal experience you'd bring to a lifetime position. Senator Schiff probed a number of questions. My understanding is you graduated in 2017, have been out of law school about 9 years. Putting aside your 2 clerkships, how many years have you actually practiced law?
I've been very fortunate to have practiced law since graduating law school and after my clerkships, and I have worked on over 50 cases. I filed over 100 motions in federal and state courts at every level, and I currently manage a litigation docket of over 100 cases. I'm very grateful.
The focus shifts to Miss Lane, and the mood turns from skeptical to outright critical. Coons goes after her experience or lack thereof. Imagine being nominated for a lifetime federal judgeship after only 9 years out of law school. Coons starts counting 1 cross-examination, 1 deposition, 0 direct examinations. You can almost feel the temperature in the room drop as Coons grills her on these numbers. She keeps trying to pivot to her wealth of experience and managing a docket. But Coons isn't interested in management. He's interested in trial experience. He brings up a bombshell to close it out. That her legal team was held in contempt for flagrant disregard of a court order. This is the ultimate red flag in a judicial hearing. If a nominee who is being asked to uphold court orders has a history of disregarding them, It's a non-starter for the opposition. Coons' closing statement was a total rejection. The combination of your lack of experience and that weighs heavily against your nomination. In 2026, we are seeing a trend of younger, more ideologically aligned nominees being pushed through, often at the expense of traditional, trial-hardened experience. This hearing was a perfect encapsulation of that friction. Is the goal to have an experienced judge who knows the rules of evidence, or a loyalist who knows the rules of the administration? Make sure you hit that subscribe button if you haven't already. We're going to be following the committee vote on both Westerkamp and Lane to see if the experience argument actually holds weight in today's Senate or if party loyalty wins the day. You won't get this level of breakdown anywhere else. Hit subscribe, stay informed, and I'll see you in the next report.